Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Surprise! Surprise! Surprise. If you didn't get a notification, that's because it was a surprise. Because I didn't know I was going to do this either. I did. I saw Runkle's stream. I was laughing my ass off. Praise be. Praise be. So many things to talk about. We have so many things to talk about. I got a whole new desk. I got a whole new setup. Things might not be working right, but that's why I thought we would do this and go live and give it a go. We're just going to give it a go. Gonna give it a go. Let's check it out. See how it is. Let's go Patriots. An old Gronk t-shirt that I have here. Well, we fell into a new trial this week. And wow, talk about a modern day lynching in Georgia. It is insane. It's wild. It is To Kill a Mockingbird in real life, in real time. And when I started covering the Georgia versus Edrick Faust trial on Monday, I really had no idea what we were getting into. I thought we were just getting into a cold case from 25 years ago. And I thought, this is going to be, interesting. Because the victim in that case, Tara Baker, was a 23-year-old law student. She went to law school at the University of Georgia. She was tragically murdered. I've heard from so many of you who were attending Georgia at the time, who were in law school, who knew Tara. And this murder, all the way back in 2001, rocked your worlds. It rocked your worlds. And there had been speculation that her boyfriend did it, Chris Melton. He was never arrested. Nobody was ever arrested in this case until 2024, when a black guy named Edrick Faust was arrested. He never even appeared in the court in the police file at all until 2024, and now he's on trial for 12 felony charges, including at least 5 or 6 counts of murder, malice murder, all the murders. And they've so far, in 5 days of trial, shown just about zero evidence against this man. They have introduced for the first time in the United States history of court proceedings, of trials, local iodine testing. It's never been admitted in any court in the land before, but this judge, oh boy, and she's giving Judge Kearney and Judge Gull a run for their monies. At least a lot. She's a lot. And I don't know what they have. Thankfully, I'm not alone in my credulity straining, because Runkle started covering it last night. And as I was watching, I think it was last night, his coverage of the openings, I was thinking, okay. It's not just me who thinks this is insane. Presumptive testing for the win. Yeah, it's presumptive testing, and it's an expert who literally, I mean, after all of us collectively, us, those of us who believed that Kearney was innocent from day one, that John O'Keefe was not hit by a car and a car did not hit John O'Keefe, and the Daubert hearings that we sat through for experts that were who were clearly qualified. Marie Russell, with over 40 years of emergency room experience in not only hospitals, but prisons, treating dog bites and all kinds of car accident injuries. The days of Daubert hearings that they flew in the matron saint of the Karen Reed trial, Dr. Marie Russell, for. And, just, it was close. Remember Judge Kearney said, it's close, but I'm going to let her testify as an expert. It's close. And the Daubert hearings that the ARCA witnesses, the crash daddies, engineers, I forget what their degrees were in exactly, mechanical engineering, accident reconstruct, all kinds of engineering, all kinds of really smart things. They were very, very highly experienced, and the Daubert hearings that they had to sit through, and the times where she just didn't even grant a Daubert hearing for any of the prosecution experts. The witness that this judge allowed to testify as an expert in, I'm not forensic chemistry and forensic biology. No shade to her age, but she graduated college in 2022. She had only been testified as an expert once before in a case in Colorado, and not for the subjects that she was qualified as an expert in this trial to testify in. It was insane. If you haven't been watching it, come watch it with us Monday. We man Shannon just waltzed right on in. Shannon with one N. Everything was a lie about him, but let him in. She seemed like a lab tech. She kind of was a lab tech. It was like she was a lab tech, and then she watched them do 3 experiments, and then they gave her some sort of certificate. I'm not even really sure. I don't even really know. I'm still confused because I was so sick on day 2. I was really getting sick, and then day 3 I had to just stay in bed all day, and we didn't cover day 3 yet. We covered most of it. I'm going to try and cover the rest of it tomorrow. My brain is still foggy from whatever it is that I had, and I feel validated that Ian Runkle started covering it and that he's seeing what I see. And the only evidence they have is true allele DNA 24 years later, but the swabs were mislabeled, and the way that they were sent into the DNA lab in California where this girl was qualified as an expert, there's no chain of custody. It's like pinning it on the black guy. And the witnesses are wild too. It's like witnesses called the police because after the day of the murder, she was completely, the boyfriend's hands, the pictures of the boyfriend's hands that were all cut up. Like this poor girl, Tara Baker, may she rest in peace. She was beaten. Then she was stabbed. And then she was strangled with a printer cord from her room. And the transformer on the cord had a hair on it that matches the boyfriend's hair. Wait, I just saw somebody's really good username go by. There it is. Melton's Lie-a-bye. Chris Melton. Is that for Chris Melton from the Faust trial? See how quick you guys are? You're so smart. The hands, his hair, Chris Melton's hair, the boyfriend's hair, stay with me. I know it's hard. The boyfriend's hair was found on the printer cord that was used to strangle her, the murder weapon. And then the house was set on fire using a chenille Afghan that belonged to one of the roommates. It's important to note that the roommate, Ashley, who testified, is married to the same guy she was dating in college or grad school, whenever she was in grad school, I think at the time, who is still probably good friends with Chris Melton. You can't make this up. The house was then set on fire. The front door and the back door were dead-bolted, so you either needed to have a key or dead-bolted from the inside, and all kinds of evidence went missing, like the screen on the back window that they thought didn't really show forced entry. Everything was wiped down. Melton's alibi was never really checked. Maybe there's video of him in a bank going to a teller to get $480 at 9:08 in the morning. But the witnesses that came in to testify after the murder happened, there were a couple. They tracked down, or they at least got, thousands of tips or tens of thousands of tips, according to the prosecutor in his opening statement, which was wild also because the entire opening statement was in defense of this guy, Chris Melton. He didn't even mention the defendant's name at all until maybe the end of it. Where was I going with that? The witnesses that came in to testify, selective witnesses, of course, because, there were tens of thousands of tips or however many tips called in after the murder. There were like 3 or 4 witnesses that came in to say that they saw a black man walking in their neighborhood around 8 in the morning. And it was very suspicious because not only was he wearing an orange shirt, but he seemed very awake for that time of morning. He wasn't running or anything. He was just walking regularly in an orange shirt or hoodie, depending on who you listen to, depending on who changed their testimony. Because apparently walking while black in 2001 was a crime. They even did sketches of this black man. What they have not shown you, and I have done, trust me, I've done the full Alice on this one. What they have not told you is that several witnesses saw a white man in jeans and a white t-shirt running away from the scene. And there's a lot of other people out there on the interwebs that have been covering this story for years. And there was not only was Chris Melton a suspect, there was another suspect, perhaps a lawyer who worked at a firm where Tara was working. Another white man. All the hairs that were found were Caucasian. But what they're not telling you also is that that neighborhood where they lived in Athens, Georgia, was a cut through to the Walmart. And many people walked that way to go to Walmart. And it would not be unusual for someone to be walking to Walmart at 8 a.m. So when you hear people out on the internet saying, Melanie has abandoned Karen Reed, she didn't even cover her hearing on Tuesday. How gross of her, how she's just, whatever they're saying, I don't even really know, except for what you said. I don't send it to me because I don't want to know. I don't want to hear about it. I don't care. I'm actually covering another live trial for a man who's the defendant who really, really, really needs the attention on his case. He really does. They want to put him. I don't even know if they've decided if they're going to seek the death penalty against him. Because, wait a second, let me just do a quick Google search. Hold on a minute. Because I found a plea deal in the file. And they offered him a plea like in mid-January and said, if you take the plea, we will not seek the death penalty. And, we still have time to do so. So I'm just making sure that the district attorney, Yamalama Ding Dong, is not like, oh, no, they still do. They still do. It's still active. The death penalty is still available in Georgia for specific severe crimes like malice murder. Well, of course, he's charged with malice murder. Of course, Edrick Faust is charged with malice murder. And this is in real time some of the most horrifying. Richard Allen's trial was horrifying too, but we didn't get to see it, right? We didn't get to see it. We had to hear about it from the law tubers and other YouTubers out there doing the Lord's work, like Bob and Ali Mata and Lawyer Lee and Andrea Burkhart and, the people who actually showed up at Rick Allen's trial in Bumblefuck, Indiana, and had to sleep outside in soccer mom chairs or hire line sitters to get into court to see what went on with Rick Allen. We're actually getting it. We're getting to see this. Okay. We're getting to see it. It's horrific. And we got cupcakes. We got cupcakes in court now. So you guys are out there doing the Lord's work. You're bringing attention to it. And I love you for that. I love how fierce you are about justice. I love it. And so when I did not stop covering Edrick Faust's trial at 3 p.m. on Tuesday to cover Karen Reed's civil hearing, please do not be mistaken that I have abandoned the Karen Reed case, because I haven't. But number one, I'm heavily invested in something else right now. Number two, that's not my only content. And number three, the judge who is handling the O'Keefe versus Reed trial in Plymouth has made it pretty clear that unless you have court permission, you're not allowed to live stream the Zoom hearings. And, there's a lot of snitches out there in the coming from inside the house, if you know what I mean. So there's that. Yes, and Next Witness. Oh, let me just shout out to Next Witness. I mean, somebody sent me actually, I was watching something else, and then I ended the stream of what I was watching, and then your new video about me popped up, and I was like, what is this? Last night at I don't know what time it was, 9 or so p.m. I don't know what time you put it up, but I just wanted to cry. I was like, Next Witness has been out there asking people to send him or her, we don't even know each other, clips about my passion for the Karen Reed case so that you could make a compilation video of all the work I did for 2 years on that case. And I want to thank you from the bottom of my heart for doing that and for taking the time to do that. And I thought it was going to be 10 minutes long. It's an hour and 15 minutes long of the best clips. And it's just me mostly yelling into a microphone like I've been doing since the beginning of the case. But it's interspersed with the video that I did, the last show that I did before I went to Mexico, when I had just had it with the trolls. And I was like, these people are out there on this fundraiser for Karen Reed as if they speak for Karen Reed, and I can't do this anymore. The channel is Next Witness. I have his or her comment up on the screen right now, and they're saying we are here for what you want to cover, and I love that so much. Please go over to Next Witness, give them a sub and a like, check out the compilation video, all about me. And I mean, I'm honored and humbled, and I could barely even watch the whole thing because I don't like watching myself in the first place. But that, and interspersing it with the last video that I did, which was after I counted all the hours that I did on Karen Reed, which was 700 and something hours, and exactly 227 videos, which is wild. I did that stream, and then it was that pieces of that stream were interspersed with clips from the 2 years of coverage that I did, and some of the funniest stuff with Mark Betterow when we were doing the the day of Rescue Randy, and and the 'tis only a flesh wound, and the Monty Python, and Kelly Reed coming on after the verdict, and some of the very original videos that I did. Oh my God, it was amazing. Thank you so much. Thank you so much for that. Really well done. Really well done. And I loved it. So there's that. So yeah, so the hearing is boring anyway, but we're gonna watch it because I guess you want my take on it. So I'll watch it with you. I'll tell you what's normal, what's not. Proctor lost his phone. Is anybody surprised that Proctor lost his phone? Proctor lost his phone. And then Karen Reed hit reply all on an email, and now there's a pissing match to try and get that email back. And then, but we have the Aidan Kearney order. Maybe we'll do that first. We'll do the Aidan Kearney order first. That came out after the last hearing that we watched about Cosgrove's potentially being recused on that or disqualified on that. And then we've got news that Greg Connor, the prosecutor in Brian Walshe's case, has decided to throw his hat in the ring and run for DA. And I'm sure that he's going to have the full support of Michael Morrissey. And if you haven't watched Microdot's latest video, what are you doing? I watched that last night too, and that was really good. Yeah. The Lugal scientist girl was a child. Yeah, she's yeah, yes, and yes. I have also dug into the pretrial rulings on that case, on the Faust case, and I have a couple of those to go over with you tomorrow. So when everyone keeps saying, why didn't he make that 412 motion? Why didn't he make that 412 motion? Guess what? He did. He did. I've got it. I have it. And when the judge in Faust keeps telling him, if you keep making these tantrums, and then she sanctioned him $1,000 in openings, like it was wild. Once I started getting into the pretrial rulings, now I understand why he's behaving the way he's behaving. His tantrums are warranted. When you see, you thought the Karen Reed pretrial shenanigans were bad? You ain't seen nothing yet. Baby, you ain't seen nothing yet. This man is being hung out to dry, and there's nothing I love watching more than acquittals, right? Some of the best times that we've had together. I mean, Karen Reed was a unicorn. We're never going to probably get a case with that much public support again to cover together. And her acquittal was, of course, it makes me cry every single time I watch it. But the Brian Camp acquittal will never not make me cry either. Brian Camp, during the very short trial that we watched together, from what we could cobble together from court TV, because they only had bits and pieces of it. Do you guys, who was with me? Raise your hand if you were with me to watch Brian Camp acquitted in Hampshire County, Massachusetts, when he killed the home invader that tried to kill him and his girlfriend and their babies. Right? With Tom Kokonowski doing his thing. Who was with me for the Penny McGee acquittal by Judge Kearney at a bench trial? I mean, there's nothing. Yeah, Bo is here. Bo was in the courtroom with Brian Camp. Bo was in the courtroom with Brian Camp after we started covering it. She went there because that's the way you guys are. Like you guys need a cause sometimes. Sometimes you need something to believe in. And when you believe it, you show up. You go, you make signs, and Bo was practically holding Brian Camp's hand in the hallway. Tell us if you were, because you probably were. When he was so nervous about the verdict and about testifying, and you were telling him that he's got a cupcake army behind him and showing him the videos of gossip, rumor, and innuendo, Kathy's funny videos about Brian Camp, and keeping him company and doing the Lord's work there. And he became our adopted son. Like we were so invested. We get so invested in these things. So if you need something else to believe in this week, come catch up on the 4 shows that I've already done on the Faust case. It's unlike anything we've done so far. And there's nothing I like better than watching an acquittal with you. And I hope and pray. And I have Tiny Jesus now. Where did I put Tiny Jesus? Tiny Jesus is here. When I was in Mexico with my sister for Dave Matthews and Tim Reynolds, they do a whole swag swap thing. People make swag. They make swag. They make personalized things, and they just give them away. They trade them. Like, for example, here's a koozie that I got that says there's a Dave song for that. And people just swap, and they give away stuff and stickers and look at these bracelets I got. Bracelets, all kinds of things. And somebody hid Tiny Jesus. All right, Mitchell. I heard you. Do you want to raise your hand for the 5th time about the affirmation, Mitchell? Mitchell, do you need to interrupt the class constantly? I've got it right here. Thank you for your compliment. Somebody in like with the swag swap hid Tiny Jesus, but only 2 Tiny Jesuses. And they had like a Facebook group, and they're like, okay, I'm going to put 2 Tiny Jesuses around the resort. And it's an enormous resort. And of course, there was a blizzard. Remember, my flight got canceled. My sister couldn't get back to the West Coast. And she found the Tiny Jesus. After she found the Tiny Jesus, I ordered this one from Amazon because I had to have one for myself. Everything started going right. It's amazing. So we have Tiny Jesus right here. Nurse Kim started the Tiny Jesus trend, I think. I don't know if she's got the same one. It says Jesus loves you in a little thing. No, I forgot what I was talking about. Oh, Susan's been here since Kevin Costner's divorce. Yes. Thank you so much. That was my first. Kevin Costner's divorce were the first videos that I ever did on my show, ever. My first live stream. And I thought, nobody's going to show up. It's going to be so embarrassing. And then Duty Ron, I had done a bunch of shows with Duty Ron and Ed. And I had like 200 people in my first live stream. I was so excited. So excited. I thought it would just be like my family. But it was amazing. I'm feeling a little bit better. Thank you. Not 100%, but a little bit better. A lot better than I was during the week. So if you get whatever it is, what can you do? You go to urgent care for what? What are they going to do for you? Hydrate, rest, Mucinex. That's what I recommend, Mucinex. Turned me right around. Hold, please. Turned me right around. Here's our affirmation for a badass of the day. Let's pull it out. I got a whole box of props over here now. I got everything. We're getting, our deck is getting very thin. Look how many cards we have left. Not that many. Oh, throat coat tea is my go-to. Throat coat tea is the best. Made with slippery elm. It's the best. There you go. This is our badass affirmation. Okay, it's perfect, Mitchell. I'm glad you reminded me, even though I already knew because I had the deck right here. Ready? Here's your badass affirmation of the day. F what others think. Do what makes you happy. Praise be. F what others think. Do what makes you happy. Listen, I tell this to my kids, to my girls. Don't ever leave the key to your happiness in someone else's pocket, okay? No one else. Don't ever leave the key to your happiness in someone else's pocket. F what others think. Do what makes you happy. Do what makes you happy. It's about you. Nobody else. Real Sudafed. Yeah, I think they lock it up though, right? I think you got to go like behind the counter and do the thing. They lock up the eye drops now, okay? I have to call somebody to unlock the Visine. First of all, you can't find Visine anymore because there was a woman who put like Visine drops in her husband's coffee and then like she killed him. And then now they don't even, you could barely find Visine. Good luck. But if you can get yourself some Roto or some Clear Eyes, you got to have somebody come and unlock them for you. I don't know. I too am a member of the We Do Not Care Club. We love her. Her name's Melanie too, by the way. I am a full-fledged member of the We Do Not Care Club because we just do not care. Tell me what else you don't care about, because there are so many things that I just don't care about. I just don't care. Okay, all right. Due to popular demand, we're going to say, well, first thing we're going to do here is take a look at the Aidan Kearney decision. This is the decision or the order that came out after the last hearing that we watched together on the sham prosecution of Aidan Kearney. And this is Judge, I don't know, Judge Whoosey-Watsy. Hold on. Judge Whoosey-Watsy. Oh, Judge Belezos. Yeah, that's right. Judge Belezos. Okay. Oops. Come back to me. Here was the order that was issued after that January 30th. Was it all the way back on January 30th? Today's Saturday, February 7th, 2026, and it is already. How do I get rid of that? It is already. That was all the way back on January 30th. Here you go. This is Aidan Timothy Kearney, Commonwealth versus Aidan Timothy Kearney. This is paper number. It is now paper number 130. And this is from Judge Belezos, and this is an interim order regarding the motion to disqualify. So this is not a final order. This is an order for now. It's like just an order for now. This is a now order while I decide the other orders. Interim order regarding motion to disqualify, papers number 110 and 117. Correct me if I'm wrong, but 110 and 117 are the motion to disqualify and the motion to dismiss, right? Unless those are both supplemental affidavits on the motion to disqualify, which that may very well be true. After hearing on January 30th, 2026, the court makes the following interim order. 1, the court will defer on any ruling regarding papers number 110 and 117 until March 13th, 2026. So let's kick the can down the road for just about another, I don't know, 6 weeks. No later than March 6th, 2026, Special Prosecutor Cosgrove will inform the court in writing if he intends to have an assistant special prosecutor available at trial in the event that Ms. Gattani is called to testify at trial. Then there's footnote number 1, which reads, the court reserves on any ruling as to the scope and or admissibility of any potential testimony by Ms. Gattani. Well, there's been no motion before the court to exclude any testimony of Lindsay Gattani. There's been no motion in limine to admit her to. I don't know what the hell that means, but pretty sure the defendant is entitled to call whatever witnesses he wants because he's got the right to a fair trial. But, just toss it on in there to make it look like maybe you could potentially decide in your infinite wisdom that you're not going to let Lindsay Gattani testify. Yeah, I don't really think that's going to go very far. Yeah, I don't know anything about anybody from 3 doors down dying. I didn't hear that. I'm sorry to hear that. If that's true, that's terrible. But, also understand a lot of people like to come into the chat and spread things that are not true. I don't know how many times I've read out there on the internet that somebody's died and it's just like a joke. Like there's nothing funny about that. Understand also, don't always believe what you read in the chat because people will put fake stuff in there just to get you to believe it. Hold, please. Thank you, Xterra, for coming in tonight. Thanks for coming in. I appreciate you so much. This is the dawning of the age of Aquarius. Sure is. Oh, 3 doors down. That's terrible. But I can't break to talk about it because I don't have the details right now. I'm sorry. So he just had to throw that in there. Then number 3 says, in the event that the special prosecutor Cosgrove intends to have an assistant special prosecutor available at trial for the purpose of cross-examining Ms. Gattani, such assistant special prosecutor must file their notice of appearance with the court no later than November 23rd of 2026. Well, sounds like Judge Belezos doesn't want to decide this motion because he's going to give Cosgrove until March 6th to tell the court whether or not he intends to have an assistant special prosecutor available to potentially maybe cross-examine Lindsay Gattani if the judge is going to allow her to testify, but he doesn't have to tell him who that person is until November 23rd of 2026. This is a bullshit, bogus ruling by a judge who clearly doesn't want to, decide anything right now. It's ridiculous. It's a clear conflict for Cosgrove. It's a clear conflict. This was not even signed until February 3rd of 2026. And why? Because you don't want to decide. So all Cosgrove has to do is say, yes, by November 6th, I'm going to have a special prosecutor available to cross-examine Lindsay because I can't do it because it's a conflict for me. But he should be conflicted off the whole case, as we all know. Anybody who's, ever read the Code of Ethics. And then the antis are saying, yeah, but then everyone would just go file a lawsuit against the special prosecutor so that they couldn't, or have somebody do it who was a witness or going to be a witness so that they couldn't examine them and they'd have to be disqualified. It's not really what had happened here. You know what? There's anything that I could be less interested in right now, no shade, than what is going on with the Guthrie case. Because if you want to go watch that, there's every single other person on YouTube is covering it right now. So if you want to go watch that, please, by all means, go on. I'm not stopping what I'm doing to talk about it. I'm just not. So all Cosgrove has to do basically say, oh yeah, by March 6th, I intend to have someone. And then the judge can say, okay, well, he intends to have someone, so he doesn't need to be disqualified because that resolves the conflict in my own mind. And then Cosgrove doesn't have to do anything until November 23rd of 2026. The election for new district attorney is, I guess, going to be in November, but that new district attorney would not take office until, January. So even if there's a new district attorney, well, there's definitely going to be a new district attorney elected, but depending on who it is, they could choose to not prosecute this case. We'll see. We'll see. Greg Conner has now decided that he's going to run. Does he have the full force of Morrissey behind? Is Morrissey going to endorse him? I mean, that's the old guard. Norfolk County people, if you want the old guard to stay in power, then vote for Greg Conner. If you want a new guard to come in, then vote for Adam Deitch. There are some other people who have thrown their hat in the ring that should probably just, at this point quit so that they don't split the vote. And so there is that bogus ruling. Okay. Hold on. And we'll see what happens, but I can pretty much predict what's going to happen. Cosgrove is going to say by March 6th, I'll have somebody else, and then he doesn't have to decide the motion. He won't disqualify him. And that's that. That's my, best guess of what he's going to do, because if I would never put money on what any judge in Norfolk County is going to do about anything, because I would lose money every single time. Every single time. So there's that. That is one thing that we did not cover together. Okay. And that's my thoughts on that. Let's take a look at the Karen Reed civil hearing, because that's what everybody wanted to hear. And I think it's super boring because, this was my life for a very long time, civil litigation. And these hearings are really boring and nothing often gets done and nothing gets figured out. And it's just a whole bunch of people on a Zoom screen. But let's listen to it for a few moments. People were horrified that I didn't interrupt my regularly scheduled live streaming of a new trial to cover this hearing. So here you go. Here's what you missed. It doesn't even start, like the law and crime feed doesn't even start at the beginning.
If you wish, Your Honor, but I can confirm that we have some very technical folks on our end that have been trying to access the documents for the same purpose of moving this case forward, and it's been difficult. And so now we're put in the position of trying to take what has been produced and get an e-vendor involved, which is going to cost more money, of course, but we're getting an e-vendor involved, just as Mr. Diller is, to try to better.
This is an attorney for one of the bars. I'm not even sure which one. CF McCarthy's or the Waterfall. And they need to get an e-vendor involved. An e-vendor, which, electronic discovery is big business now. It's big business. These e-vendors make a lot of money. There's like 1 million pages of discovery already in this case. And it's hard to transfer that. And law firms are not equipped to do this. They're not equipped to do this. They don't need to buy this super expensive software, because when you're a lawyer, everybody tries to grape you over the coals to buy all their software to do all kinds of things and and stuff, and electronic discovery tools and software, and it costs a fortune to run a law firm nowadays. So that's what they're going to have to do, because there's at least 1 million pages of discovery. There's also all these videos, and here she's going to talk about it a little more.
Access these documents. And then I would just say too, from what I have been able to see with the 518 videos, they're not, as far as I can tell, categorized in any way. My operations manager has told me that we can see that there's driveways, there's Ring doorbells, there's some body cams, there's cars backing up, which I can presume is Ms. Reed's. There's some audio files that sound like they're coming from dispatch, but nothing is date and time stamped. We're having a difficulty sort of trying to weed through it and discern what is relevant and what is not relevant from those videos. And then with respect to the folders that I believe Mr. Rosenberg has referenced, we're having a hard time opening those as well. They seem to be either corrupted or not in a proper archive format, to the best I understand what my technical people have told me. So I can just say, Your Honor, we are having some similar difficulties that we would love to get past with the cooperation of all parties in the court.
It's kind of like they started this hearing sort of right in the middle. Or some time had passed before Law and Camera got their camera up for this. So that's what we got is what we got. But there's a ton of electronic discovery. None of it's labeled. None of it's organized. It's a mess.
What depositions, if any, have been noticed by CNC?
We have not noticed depositions for two reasons. One, there will probably be very few from us, Your Honor. But two, we want to only notice depositions that we truly intend to take and are not duplicative of other parties. So we have talked with Mr. Diller and conferred with him on the short list of folks that we would anticipate that we would like to depose. And frankly, we've also talked to counsel for Waterfall about this. And then, of course, Mr. Diller has talked to me about some of the folks at McCarthy's that he would be looking to depose. But on both.
She's the attorney for CF McCarthy's. That answers my question. Noticing a deposition is nothing more than this. It is simply sending a notice to a party saying, we intend to take your, please take notice that we intend to take your deposition on this day, at this time, at this place. And then you send it to all co-counsel. You'd have to subpoena the witness if they're not a party. If they're a party, it can be a notice. So, for example, they may want to send a notice of deposition that they want to take the deposition of this person who worked at the waterfall, this employee from the waterfall, to authenticate video for whatever reason. And they would have to send a notice of deposition on Waterfall's attorney saying, here's who they want to take the deposition of at this time in this place. They can also do non-party depositions of people like the House defendants. So there's going to be lots and lots and lots of depositions. But when he says, tell me about the depositions that you've noticed, that's all. That's all they mean by that. Jen says, I drive for Uber and I'm going to make everyone listen to you tonight. That's hilarious. As if it's some kind of punishment. Thanks, Jen. Thanks for doing the Lord's work. I hope may no one throw up in your Uber tonight. It is the night before the Super Bowl, AKA just another amateur night. And I hope that doesn't happen to you. Moving on.
Sides, it's a relatively short list, Your Honor. And as soon as we get through these documents, we are in a position to proceed with that type of discovery and with depositions.
Thank you. Why don't I hear from Waterfall, please?
Thank you, Your Honor. David Hassett. Judge, we have responded to the plaintiff's discovery, interrogatory answers, and document responses. We've also propounded discovery to the plaintiff and to the individual plaintiffs identified in the suit. That discovery is outstanding by agreement. As to the documents produced, we also have not yet commenced deposition. The documents that we have gotten through the discovery to date, we've been working through in expending efforts to get to the documents, understand the documents. We've had some challenges, but we've been trying to implement some workarounds, but that is not completed yet. And we also have a discovery e-vendor that will be assisting us in the pursuit of getting our arms around all those documents. We have been in discussions with Attorney Diller and Attorney Smith about the depositions we would be taking. There are obviously some overlap with the depositions that the Reed team would be taking and the O'Keefe team, but that the separate depositions of patrons or witnesses, we conferred about those. I agree it's a relatively short list, and the hope was for us to review the documents before starting that process.
Attorney Hassett, do the challenges you have encountered include the inability to access the documents produced?
Not all of them, Your Honor. We have been able to access documents, but we haven't been able to access all the documents. For instance, some of the folders that were described by Mr. Rosenberg and Mr. Diller, they will open up and they'll be blank, there'll be nothing in there, or they're corrupted. I believe we've had some communication with Mr. Rosenberg's office about some access to files in our own IT support internally. So what I would say, Your Honor, based on 990,000 pages, there is a percentage that we haven't accessed properly or completely. One thing I will also add is that there is a load file that we recently received that has metadata. It appears that
Metadata? What? What is this metadata of which you speak? A load file. Someone's spreading their load. Oh boy, the memories, not good ones.
Will assist in terms of accessing documents or files that we've struggled with. So that's something that we intend to do next.
When did you receive that?
I think it was in the last week, Your Honor.
Okay.
Your Honor,
Thank you.
can I just note, Your Honor, I haven't heard from either of the two bars about these issues. I'm happy to work with them, just like I've been working with Mr. Diller to have these documents have
Okay, so that's Aaron Rosenberg. Wait, let me
Assist
zoom in
with
on him a little bit. He's Damon Seligman's partner, so he represents Karen Reed. This is Aaron Rosenberg on the top here. He's the one speaking. The thing I'm most interested in about with regard to what Mr. Aaron Rosenberg has to say is, what are those posters behind him? That is what I am most want to know, because they look like concert posters to me, and I am super interested in that. But aside from that, the rest of this is boring as hell. Here we go.
Technical issue that they're having. I just haven't been aware of those yet. So if they reach out to me, I'm again happy to help with that. But I understand there is a lot of paper here, and there is a need for e-discovery vendors because primarily the plaintiffs have asked for all of these million pages of documents. So I understand why all of the parties are explaining the need to access things in order to go forward and proceed even further with discovery. But I just want to be clear, there, to the extent there's any technological issue, parties need to reach out to us and let us resolve those, which we will do.
Mazza.
But the common theme seems to be that they're all having some difficulty.
Well, I agree with you based on what I just heard, Your Honor, but I'm not aware of that until just this moment. The only part.
If nobody has reached out to him to tell him that they can't open the files, how is he supposed to do anything about it? Hello? Oh, you think Cardi B will play like at the halftime show tomorrow with whoever's playing at the halftime show tomorrow? Because you know she's going to be there.
Party I've conferred with about these issues is Mr. Diller, and we've been talking about it for, I think we'll agree we've been talking about it for a month or more. So I'm more than happy to do that, and I don't know what the issue is from the other defendant's perspective. I know from Mr. Diller's consultant what the issue is now, which I believe we've resolved, and he's said he should be able to know that shortly. So I would suggest I'm happy to speak with anyone that needs to in the next couple days to address any technological issues that are remaining.
Don't wait until you're in front of the judge for a conference to say you can't open the
So,
discovery.
Attorney Rosenberg, in November,
And that you never reached out to Rosenberg to tell him that so he could fix it before you get to the conference. Not a good look.
Attorney Waters indicated that the Reed team had sent out between 10 and 12 subpoenas.
That's correct.
And it appears you've resolved, at least for now, issues relative to Sergeant Good, Mr. Proctor, as well as the Norfolk County District Attorney's Office. That's 3. Who were the other parties that notices of deposition went out?
So there's only been one. There's only been one.
Well, Attorney Waters indicated between 10 and 12. I've just addressed 3 of them, so that leaves 7 to 9. So you said there's only been those 3?
No. So the question to Attorney Waters at the last hearing was subpoenas. Those were primarily document subpoenas. The deposition subpoena and the notice of deposition, which is the only deposition that's scheduled thus far in this case, is our deposition of Michael Proctor, which we've finally locked in with everyone's availability, all parties, counsel, and Mr. Proctor and his counsel.
What date is Michael Proctor's deposition going to be? That'll be exciting. We'll never probably see it, but that'll be exciting. I hope they're going to videotape it too.
Counsel's availability, and that'll be going forward in April.
Ooh, April.
We have not yet.
See how slowly the wheels of justice and civil court turn? Not until April. That's the only one we got scheduled, and it's in April.
scheduled other depositions, but we from the Reed side plan to do so very shortly. And as you can tell, obviously the discovery from our end is going to be primarily third-party discovery. So there will be additional depositions put on the calendar soon, as soon as we're able to coordinate schedules, which is
Haas defendants, get ready. Haas defendants, get ready to avoid service. They're coming for you. They want your depositions. Third party, when he says third party depositions, that's what he means. People who are not parties to this lawsuit.
has obviously been daunting, this case.
So just so I understand, what subpoenas have been sent out?
So we've sent 2 subpoenas to Michael Proctor because there was additional information that became, we became aware of.
If you got bored, just come back and pay attention now, because here's the most exciting part of this is when he talks about Proctor.
We sent a subpoena to the town of Canton. We sent a subpoena to the Boston Police Department. We sent a subpoena to the Massachusetts State Police, sent a subpoena to Sergeant Good, as Your Honor said. We sent a subpoena to, I don't know if I said the district attorney's office, but both us and the plaintiffs sent subpoenas to the district attorney's office. We sent a subpoena to Mr. Proctor's prior attorney in connection with his appeal, just relating to this one particular issue that is relevant to the district attorney's office subpoena. There might be 1 or 2 I'm not thinking of off the top of my head, but that's the bulk of them thus far.
When did the subpoena go to the town of Canton?
The subpoena to the town of Canton went, off the top of my head, July or August of 2025, I think.
And have you received a response?
We've received documents. We are currently discussing with their counsel additional documents that we had been under the impression they didn't have, but now I believe they may actually have. So I'm in the process of a 9C conference with their counsel to determine if they will produce these additional documents that they should produce from our perspective.
When did the subpoena to the Boston Police Department go out?
Roughly the same time. So the first subpoenas we sent all around the same time was the town of Canton, the Massachusetts State Police, Michael Proctor, and the Boston Police Department. Those were all July to August. And then, as I said, we followed up with a second subpoena to Mr. Proctor, approximately September of 2025.
Would you agree that?
So on your upper left of there's a 4 square here. The upper left is Aaron Rosenberg, one of the defendants for Karen Reed. He's the one who's been speaking most of this time. Damon Seligson is below him. He's the one we've seen speaking when in open court most of the time. South African accent. Upper right-hand corner is Mark Diller. That is the plaintiff's attorney. He is the attorney for the O'Keefes and Kaylee. And I'm not sure this young lady on the lower right, I'm not sure who she represents. Her name's Alexandra. It looks like Beaton.
8 months to resolve issues from subpoenas might be a little unreasonable.
I certainly would, Your Honor, but here's what's been happening in this case. Every time we serve a deposition, we serve a subpoena, we either are ignored by the recipient of the subpoena, as happened with Sergeant Good, happened with Mr. Proctor, happened with, at first, the Boston Police Department. Then we're presented with objections and a refusal to produce documents. We try to confer. These are government entities in large part that we're discussing right now. And it takes time to even get people on the phone. We get them on the phone. There's continued refusal to produce documents. We attempt to confer as we're required to under 9C to try and get documents without burdening the court with motions to compel. We then, in some instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth, documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor.
Yeah.
We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena,
Right.
because the district attorney's office told us they wouldn't give it to us because it had to come from him directly.
Right.
As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain it.
Proctor has lost another phone. How many phones have you lost in your entire life? I don't think I've ever lost a phone that I haven't been able to find. Does anyone find my iPhone on their phone? Oh, yes, we need the button. Props are in a new location. I have to go for the props now. Whole place. Look, I got a whole bucket of props for you guys. Whole bucket. Here's a hole in the bucket. Dear Liza. Dear Liza. He lost his phone. Did he lose his phone, or did he destroy it on a military base and crack his SIM card in half? And, you know, kind of like the phone that he replaced in 2024 and then set everything to auto delete. Coincidentally, right after he testified in front of the federal grand jury, and then he got a visit. We got a visit from Fanning and Tully at his house to have a powwow about his testimony, and then all of a sudden he got a new phone. Lost his phone within 1 week of the police giving it back to him. Do you believe that? Will this man ever see any ramifications for his behavior? Ever? Ever? Do we need to pray to tiny Jesus? I mean, what are we doing here? He just doesn't care, and he's throwing it in your face. He doesn't care. He's already lost everything. He's already lost everything. His glory, his honor, his integrity, his cojones. And his job, and his family probably doesn't like him anymore. Hold on while I admire the hall. Hold on. Like literally in the middle of something. Sorry, just 2 seconds. Hold on. All right, bye. When you have to admire the hall, you have to admire the hall. There's a whole fashion show involved, and you know, sometimes. He's lost everything. Why not lose his phone too? Right? Why not lose your phone too? You've already lost it all. It doesn't matter anymore. You've lost your job. You've been disgraced. You have been called single-handedly the most embarrassing chapter in Massachusetts State Police history. You have been dropped by your union. You've been dropped by your attorneys. They dropped you so fast that they had you sign a discontinuance to try and get your job back with the post commission on a Saturday, man. On a Saturday, the day after your entire 13-year phone extraction was released to your attorneys in that case. The union dropped you like a badass habit. You lost it all already. So why not lose your phone at this point, really, right? Because history has shown you just don't care. You just don't care. Should he be sanctioned? I mean, just because there's not like a technically an order to preserve your phone, technically you're being sued by Karen Reed. You know that it's going to be requested as evidence. You have constructive knowledge that your phone is pretty damn important, because regardless of what they got off of it, that was so bad. It also got Sergeant Good suspended. We still don't know what's going on with him. Yeah, don't start with rumors. This is not the place for that. Scott is not having that. I don't know anything about any grippy sock vacation. I have not been able to confirm that, so I'm not spreading that rumor. What's left for this guy, really? What is left? Of course, it is evidence. They've got everything. They got 13 years of his extraction. Did they get his location data too? Because that would be really interesting to get, wouldn't it? But let's listen to what Mr. Rosenberg is just laying on us for the first time. This was the other day, of course. This is not live. It is Memorex, and it's a couple days old by now, so you probably know. But if you don't, surprise!
We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for 2.5 months negotiating an agreement with the district attorney's office, which would only give us these relevant documents, despite the civil rules, would only give them to us with onerous restrictions that are unusual if never occur in civil cases like this. But we agreed to that because we need to get the documents. So I 100% agree with you. When we've sent out subpoenas, we have not gotten the responses that we should have gotten under the rules and the law. But we've had to put in a lot of extra time and effort and resources to getting these entities to produce documents. The state police still haven't produced documents. I was under the impression they'd been reviewing them for months, just found out from their counsel that they had made little to no progress, and I needed to again threaten a motion to compel in order for them to agree to produce, to do what they have to do. So
they've made little to no progress. The district attorneys, hold on a second, what? No, hold on.
I 100% agree with you. When we've sent out subpoenas, we have not gotten the responses that we should have gotten under the rules and the law. But we've had to put in a lot of extra time and effort and resources to getting these entities to produce documents. The state police still haven't produced documents. I was under the impression they'd been reviewing them for months, just found out from their counsel that they had made little to no progress, and I needed to again threaten a motion to compel in order for them to agree to produce, to do what they.
Massachusetts State Police doesn't care either. They don't care either. They don't care. They've been operating this way for decades. They don't care.
They have to do. So I agree with you, Your Honor. We shouldn't have to wait that long.
But here we are in February and we're not any further along. I detect a little frustration from you, Attorney Rosenberg, but why don't you utilize the court to maybe relieve that frustration? If you have issues that you need to bring in front of the court as far as a motion to compel, let's get them filed. This case.
I just be clear?
This judge is totally vibing with them. He's like, I sense your frustration. I can sense that you're frustrated.
It needs to start moving along.
Well, I need to be clear with Your Honor, and I'm hearing you don't want us to confer with these parties and continue to drag out those conversations. The rules, I believe, would require me to do that, and I can't just come into court asking for a motion. But if you'd prefer us to handle it this way when we get non-compliance from a subpoena recipient, I'm happy to do that. I just am sensitive to the requirements of 9C.
I'm not suggesting you ignore any of the rules. I'm suggesting you avail yourself of the opportunity to use them.
The judge is in the lower left-hand box. He's like a little tiny man. He's like a little tiny judge. He's like as tiny as little Jesus. Tiny Jesus, like tiny judge. He almost sounds like the wizard, behind the curtain in the thing. I would zoom in on him, but this is as big as he can get. He's just like a little tiny judge. Oh.
Suggesting that the length of time that it has taken to resolve issues that shouldn't really be issues appears to me to be excessive. So we have to figure out a way to bring them to a head.
Well, the head is, Your Honor. It's an interesting word choice. Bring it to a head. You got to tell these mofos what's up. You got to tell the Massachusetts State Police and the Norfolk'd County DA's office that they just can't ignore subpoenas. You got to tell people like Sean Good, when you get a subpoena good, it's real bad to ignore it. Tell me something good. Why do you feel like subpoenas don't really apply to you? You already got suspended for whatever it was that was found on Proctor's phone. And Mr. Proctor, you can't go around ignoring subpoenas either. There needs to be some ramifications for behavior. You know who got some ramifications for their behavior this week? Attorney Ahmad Cruz, CREWS, our new king of defense attorneys, in the Edrick Faust case for zealously representing his client. He was sanctioned and fined $1,000 by the judge during openings that he was required to bring to court in cash. I don't even know if it was in cash the next day by 9 a.m. Okay. You need to show these folks, tiny judge, that they cannot just ignore subpoenas, hold them in contempt, sanction them. And I did feel very bad for Ahmad Cruz. That was not right. And the district attorney is scumbaggery for even having requested it. But that's where we are in Athens County, Georgia, Athens, Clark County. So you need to sanction these people, Judge.
Well, I agree with you, Your Honor. It's just, it's excessive from the recipients of the subpoenas. We're certainly not delaying anything. We've been demanding documents since July, and we've been out there taking discovery and trying to move the case along, which is what we intend to continue to do. So as soon as I have a situation where the recipient of a subpoena is not engaging in good faith conference under 9C, we've been filing motions, and we've had, I believe, 3 or 4 before, Your Honor. Then the parties who have received the subpoenas seem to all of a sudden be more willing to comply just before we have hearings with the court. And so we are using those tools, and we'll continue to do so. And
I will remind you, Aaron Rosenberg is the defense attorney here. He represents Karen Reed. The burden in this case to prove is the plaintiff. Mark Diller is the plaintiff. This is the guy who's got the burden to get all discovery. Aaron Rosenberg is carrying the load here by doing all this work and stuff. But yeah, exactly. Vesper's like, I don't know how you deal with these noodles and half-wits all day in, day out. I must have had nerves of steel. It's like a constant battle. You're fighting with, insurance companies to pay your clients. You're fighting with judges. Well, not really fight. You're fighting with judges. You're fighting with opposing counsel. They don't want to pay. You're fighting with insurance adjusters because they don't want to pay, and your clients deserve the money. And then you're fighting with defense attorneys to give you the discovery that you're entitled to. And you're fighting to get deposition dates. And you're fighting all the time. But here's the thing. When you are a civil litigator like this, and you do it for many decades the way that I did, I'm retired now. I have my license, by the way. I can always go back and practice if I feel like it, but I'd rather sit here with you on YouTube. I just hold my license in escrow right over here until if and when I find somebody that is worthy of getting back in the courtroom for. But here's how civil litigators operate, okay? It's a pretty small pond, okay? Plaintiffs' attorneys, defense attorneys. Defense attorneys usually work for insurance companies. And so when you practice in a certain county or counties, you are going to come up against the same defense attorneys as a plaintiff's lawyer for decades. All the same firms, all the same players. You better learn how to play nice together because you're going to come up against each other for decades to come. You don't need to make enemies with everyone. In fact, most of my very best lawyer friends are defense attorneys that I've had cases with throughout the years that became my good friends because we spent so much time together during depositions and sitting in court and on trial and doing all of the things. And the fact that these guys are now having a pissing match about an email that was sent reply all is wild to me. Wild. But let's keep going through this really boring hearing a 20-minute hearing that I've managed to turn into an hour.
Anything else?
Not for me, Your Honor.
Okay, so why don't we all plan to get together next Thursday at 4:00 in the same fashion? And Attorney Diller can report on his success or lack of success in seeking to access the documents. And it'll give you and Attorney Diller a further opportunity to talk about his concerns about categorization or identification of the documents that are produced. And then I'd ask all the
Here's-
parties to,
Remember they made a big deal about this female attorney, young rising star BB Fell right here from California joining the team. Here she is in the upper left. She doesn't say anything. I don't even think that Mark Diller says anything during this conference.
submit at this point in time
Alan
the
Jackson's not there.
intended depositions. And I understand that may change, but I want to know who people intend on deposing. Is there anyone that can't make it next Thursday at 4 o'clock? Hearing no response, we'll see everyone next Thursday. Thanks very much.
Your Honor, I have a question though about the request for the intended depositions.
Oh, here's Mark
Are you
Diller.
looking for that to be a
Perking up.
formal written disclosure, or is that something that we could show you in camera so as not to make public all the parties that we intend to depose?
You can share it to me in whatever fashion you want to.
Okay,
So
thank you, Your Honor.
it's going to be like
All right.
in secret.
Anyone else have any questions?
Why should who you intend to depose be sealed? What's the basis for that being sealed or impounded, as they say in Massachusetts? In New York, if something is impounded, it's your car. Your car gets impounded when you fail to pay 1 million parking tickets. Sealing the record is what we do here, not impounding it, but what else?
Okay, thanks very much. We'll see everyone next Thursday.
Thank you.
Okay, so for the
Your Honor.
Woohoo! Next Thursday, I will not be interrupting my live streaming of the Faust trial to cover another hearing like that. I'm putting you on notice now. Don't be sad or surprised when I do not interrupt my live streaming of an actually really important trial to cover that. Here's the, here is the Mass Live article involving, this was just from yesterday, involving the announcement that Greg Conner has decided to run for district attorney. Brian Walshe, prosecutor, enters Norfolk DA race. Mama Rico 3 says, what type of emoji could we make for Mr. Cruz? I don't know. We'll think about that. I was thinking like crew, CREW, like rowing, like maybe there's already an emoji like an oar. You can use like an oar because, like rowing crew. I don't know. We got to think about that a little bit. The prosecutor who led the team that secured a conviction for Brian Walshe late last year has entered the race to replace longtime Norfolk County District Attorney Michael Morrissey. Greg Conner, who is running as a Democrat, currently serves as the chief trial counsel in Morrissey's office. He's the 5th candidate to enter the race and the first to do so since Morrissey announced he was not seeking re-election. Conner filed paperwork with the State Office of Campaign and Political Finance to establish a campaign committee on Friday. Conner will depart the district attorney's office to become a full-time candidate in March. He said his decision to enter the race came after an outpouring of support from the legal community that I should do it. In quotes. Outpourings of support from the legal community. Well, I remember saying when he was trying the Walshe case, I remember telling you guys that he is the attorney who refused to re-persecute Karen Reed. He was like, no, hell no, I'm not touching that. And that's why they went out and hired Brennan. That is what I had heard from sources inside the office. I also had heard from sources inside the office that Greg Conner almost came to blows with Hank Brennan when Hank Brennan tried to pierce the attorney-client privilege and when he was seeking some of that stuff and filing some of those BS motions, that Greg Conner almost came to blows with Hank Brennan. And I had said to you, Greg Conner has integrity. He is, maybe the only attorney, there's a lot of attorneys in the DA's office, so that wouldn't be fair to say, who is, standing up to Morrissey and saying, no, I'm not touching that case. And I thought, and I said to you, wouldn't it be interesting if he decided to run for district attorney? That was before Adam Deitch threw his hat in the ring. And so let's go on and read this here. Conner said he wanted to wait for Morrissey to make a decision before entering the race. After Morrissey announced he would not seek re-election, Conner said he made it a point to listen to the other candidates, but came away unsatisfied with their positions. They didn't know the job, Conner told Mass Live on Friday. Morrissey, who was elected district attorney in 2010 after serving in the state Senate and House of Representatives, has faced sharp criticism in recent years for the prosecution of Karen Read and the investigation into the death of Sandra Birchmore. Connor is the only candidate in the race who worked for Morrissey or any other Norfolk County district attorney. I'm running because this is an opportunity for me to continue serving for Norfolk County, Connor said, adding that he wanted to take his experience managing different units within the office and apply it more broadly. Connor's opponents, all fellow Democrats, quickly sought to tie him to Morrissey. Adam Deitch, a former federal prosecutor who announced his candidacy last year, said the county deserved a real change in the DA's office, not a promotion for Michael Morrissey's right-hand man. Deitch oversaw the federal investigation into the Karen Read case. Juna Perkins, a defense lawyer and former prosecutor, said she looked forward to hearing how Connor planned to bring meaningful reform to the office he helped run. What the Norfolk DA's office needs is systemic reform, she said. Jim Barakat, a public defense lawyer, called for a clear break from the status quo. With respect, it's hard to argue that real change is coming from someone who has been part of the same Morrissey leadership team all along. If the office was on the right track, we wouldn't be having this conversation, he said in a statement. The other candidate in the field, Craig McLellan, another former prosecutor, did not respond to a request for comment. Asked about the criticism from his fellow candidates, Connor noted that his career in the district attorney's office predated Morrissey's election to the position. Connor became an ADA in 2001 when Bill Keating was the district attorney. If people are concerned about me, I've been trying to be fair to everyone my entire career, Connor said. My career speaks for itself. So far, no Republican candidates have entered the race. During the Read prosecution, Morrissey's approval rating in the county plummeted. Just 4% of respondents to a poll conducted following her acquittal said they believed he should be reelected. Read was accused of running over her boyfriend, Boston police officer John O'Keefe, with her Lexus SUV on January 29th, 2022. But during her two criminal trials, Read and her defense team claimed that Morrissey's office was part of a conspiracy to frame her for O'Keefe's death. After the explosion of public support for Read, Morrissey published a video denouncing the conspiracy claims and supporting the civilian witnesses who Read claimed were framing her. But after that, he largely withdrew from the public eye. Oh, yes, he did. He hid in his puffy coat. Remember the puffy jacket emoji that we had for Timothy Nuttall because he swore that John O'Keefe was wearing a puffy jacket? I am now reusing the puffy jacket emoji for Michael Morrissey, who doesn't seem to own a dress coat. Yeah, I said it. And it doesn't mean you need a lot of money to be able to afford a dress coat. You could go down to the Goodwill and you could probably find a nice dress coat to wear over your suit as district attorney instead of wearing a puffy coat when you give a short-waisted puffy coat, by the way, when you give statements outside the Brian Walshe trial or any statements at all. In fact, I even think he showed up in that puffy jacket to Anna Walsh's what did they do recently for Anna Walshe? They did like something in church. They did like tell me because one of you went to it. I don't know if it was a mass. It was some sort of tribute ceremony, memorial service. Somebody said, I can't believe Melanie Little was like ragging on him that he couldn't like wear a dress coat. Maybe he can't afford one. It's like, oh, okay, that's what it's about. He sat in court sneakers on a puffy jacket. It's called respect, sir. It's called respect. Have some respect for your constituents, okay? That's all. Read was eventually acquitted of all charges having to do with O'Keefe's death. Yay! In the case of Birchmore, who was found dead in her Canton apartment in 2021. This is tragic. And Farwell has made a motion to dismiss. We're going to have to go over that as well. Wait, here's, this is, I'll do this again. Read was eventually acquitted of all charges having to do with O'Keefe's death. In the case of Birchmore, who was found dead in her Canton apartment in February 2021, the Massachusetts State Police investigators assigned to Morrissey's office ruled her death a suicide. I just realized that StreamYard has like sound effects now. But federal prosecutors have since charged Stoughton police officer Matthew Farwell with killing Birchmore and accused him of grooming Birchmore beginning when she was a teenager. I don't even want to get into the rabbit hole that I fell into about the Sandra Birchmore stuff and the Police Explorers program and Epstein. I don't know what to believe anymore. I don't know what's real and what's not real and what's true and what's not true. So I'm not gonna talk about that right now. But Greg Connor coming to the race. So how does this work exactly? Is there going to be a primary? Is somebody who lives in the county? Can you tell me what's happening? Is Deitch also running as a Democrat? So are they going to do a primary and then whoever wins the Democratic primary is just going to win? They're going to run unopposed? Like, how is this going to work? Is anybody going to run as an independent? Can you just... What's going to happen? Goodmans are here and they gifted a membership. You're awesome. Thank you. And Susan CR is here and she gifted 5 memberships because you guys are amazingly kind and generous. Aunt BB's here. She said you thought nobody would show, but the cupcakes were waiting for our queen. Oh, Aunt BB was my first member ever. 28 months ago, I guess, is when I started memberships, and Aunt BB was the first one and will always be the first one. Dina says Brad did pass away. That's very sad. Thank you for your 5. And NS Nancy says, can Belezos assign a public defender to cross Lindsay Gattani? Thanks for being here for 16 months, Nancy. But the answer would be no, because a public defender is a defense attorney and they need a prosecutor to do it. So good question. No. Dee has been here for a very, very long time also. Thank you for your $50 super chat. She says, I've been with you since your first video. I loved you on Duty Ron, and I followed you when he said you were starting your own channel. I was honored to participate in the Next Witness video compilation. Oh, thank you so much. You're one of a kind. You had me at Costner. Oh, that's what I said. He had me at Tin Cup. He had me at Tin Cup. I love him so much. Thank you so much, Dee, for your 50. Blessed Texas Lolly says, thanks for covering the Faust trial. I'm invested. Thank you so much. So am I. James is here. He gifted 5 memberships. He's amazing too. Thank you. Julie says, I'm so glad you're covering the Faust trial. Me too. I think we'll do, if you guys, I think here's what we're going to do tomorrow, because there's a lot of stuff I want to go over on that case before Monday. Monday, we're going to start late because I like to put it on 1.5 speed because, and no shade to my Southern gentlemen, so men, attorneys, they speak a little bit slower than I do. And so putting them on 1.5 speed is like normal speed and we can zip through. I also have an appointment on Monday morning. So we're going to start a little bit later. But for those of you who are interested in the pretrial rulings, I want to go over them tomorrow. I'll teleport you over there after this so that you can come and catch up. Thank you, Julie. Anna Brown says, been sick all week. Oh, you too? Have to get caught up on the Faust case. Glad you're covering it. Much love. You're the best. No, you are. You've been here for 5 months. You're great. Originally, the judge told the jury that this Faust trial was going to be a 2-week trial. Then, the day the trial started, the prosecutor said, oh, no, it's going to be 4 to 6 weeks because we have 80 witnesses. And the judge is like, I'm sorry, what? No, I told them 2 weeks. And that's why she's working every night until like 5:36. So we'll see how much more trial there's going to be. But I do not think this will be done in 2 weeks. Thank you, Anna. Nay says, bottom poster looks like Fenway. Oh, we were talking about Aaron Rosenberg's posters, right? Pokey's been here for 11 months and says, was just watching Next Witness tribute. I love your passion, Melanie. Oh, thank you. I'm going to link that video in the description below so you guys can go watch it and leave some nice comments for Next Witness and give a like and a sub. Kathleen says, I doubt Proctor's gone out much lately. Where would he lose it? Look under the bed, Chip. Maybe it's in his cup holder. Maybe it's in the same place where Kevin Albert lost his gun. Dude, where's my phone? I don't know. Dude, where's my gun? I don't know. Dude, where's my badge? Oh, well, I found your badge in my cup holder, but okay, dude, could you just drop it in my mailbox? Okay, dude. Rock on. Dude, where's my car? Thanks, Kathleen, for your 10. Love my flip-flops, pointing out that lost phone equals admission of guilt. Stand with Mel. Oh, Stand with Mel is here. What a beautiful profile picture. Are you Julia Roberts? You look like Julia Roberts. Unless that is a picture of Julia Roberts. Thanks for your 20. Says, love the next witness video. I love the way the video ended because my favorite moment was the Mark Betterow comments on verdict day. Nurse Kim would be cool to have next, but all her funny moments would take about 5 hours. She's very funny. Thank you. E320. Sue says, just sent you Richie's article on Greg Connor running at scathing. Connor let Sandra Birchmore's murder stay covered up. Oh, did Richie write an article? Oh, please. I'll look for it in a minute. There's an issue when I try and look at another screen on this same if I freeze. Have I frozen yet? Thank you, Sue35. I appreciate you. I don't have a lot of time tonight, so I don't know how much I'm going to be able to get to tonight. Elf has been here for 24 months and says, happy to see all of you. We're happy to see you too. And the Governs are here and they gifted 5 more memberships. Thank you. And look at their logo. Is I went to Cancun with attorney Melanie Little. You actually did. Many of you did come to Cancun with me this year because I tried to live stream for you a little bit. And I think we caught at least a couple of songs, right? I mean, at least 3-4 songs you guys got of Dave and Tim on the beach. And wasn't it fun? Did you enjoy it? Still here. Ireland is watching. Love you, Melanie. Thanks, Andrea. Good luck. Good luck. You can do it. Stay strong. Glamasu says, so we all feel old. Drake May was not alive when the Patriots won their first Super Bowl. I have doctor appointment at 8 a.m. Monday. Ugh. Well, I'm going to be starting late on Monday. I'm probably going to be starting around 11. So don't worry. You probably won't miss it unless your doctor keeps you sitting there for 3 hours, which is also quite possible. I am so excited that there's a 23-year-old kid going to the Super Bowl. One of my daughters said to me yesterday, have you looked into Drake May's wife? She's so adorable. She does this really cool Instagram stuff. And she's so cute. And I haven't, but I love that my kids are into it too. And I love that he's 23 and that he's going to the Super Bowl. How great is that? It's so great. I mean, I hope they win. I don't know. I got my Super Bowl boxes. So I hope that, and guess what my boxes are? 6'7". 6'7". I don't know what that means, but I think it's pretty trendy. One of my boxes is 6'7". Thanks, Suze, for your 5. And Gigi's here, and she gifted 5 memberships, and she's got my back, and that's amazing. Thanks, Gigi. And Sam with Mel says, it's me, much younger. That 80s Southern big hair. I love it. I love it. You are Julia Roberts. You could be in I was going to say Sugar Magnolia. You could be in Sweet Magnolias. Wait, is that Steel Magnolias? Sugar Magnolia. Steel Magnolias. Magnolia Bakery is like a cupcake place. Ms. Jules gifted 5 memberships too. You guys rating memberships tonight. What are you doing? Thank you. Wait, Rat House Media and Toy have a grandson? Congratulations. I love it so much. I can't wait. I can't wait to have a grandbaby. That's very exciting. First of all, I did not know that Rat House, Danny and Toy are married and have children together and now a grandchild together. And that's amazing. I really don't keep up on what's going on YouTube or any of the other stuff, but I am so happy for you because we have a model. We have a baby model and she's our gorgeous little baby. And she wears well, I can show you because her grandma is actually from Canton. I have to dig up the pictures though. And I sent her some merch to put on the baby so the baby can be the model for the Melanie Little cupcake merch. I love it so much. Michelle says, you and Nurse Kim are my favorites. I love you both. Thanks for being here for 8 months. Deborah says, hi, Melanie. Glad you're feeling better. Oh, almost. I'm almost there. I'm feeling it. I rarely get sick, but when I get sick, I get really sick. I can pull through a lot, but when I get sick, I get really sick. So thank you. I appreciate that so much. Steph says, just nothing. Just cute little profile pic with a cute little doggy and $5. Thank you so much. And Kay Willis is here. She gifted a membership. Kay Willis, if you haven't seen the Next Witness compilation video about me, go watch it because your name is mentioned in there. Hopefully it'll get you some business. Thanks for gifting a membership. And Rosalie says, glad you're feeling better. I bought Post Malone tickets because you reminded me that I need to buy the tickets. You do. Buy the tickets. Buy the tickets. See, I never saw 3 Doors Down. And you're telling me that somebody died and now I'm not going to get to. Buy the tickets. We got Harry Styles tickets for London. We're going to Wembley because it's easier than going to Madison Square Garden. Buy the tickets. You guys are amazing. Do you want If you want, I should look at the motion of the reply all motion. Do you guys want to see that at all? I mean, tell me. It's your show tonight. Tell me. I don't have a lot of time, but tell me what you want to do. Karen Reed hit reply all on an email that was BCC'd to her. Everybody know what BCC is? BCC is a blind copy. Karen Reed was blind copy on an email having to do with responding to the interrogatories. Remember, we went over a motion in which the plaintiff wanted Karen Reed to supplement her interrogatories, which is like answers to certain questions that they want answers to. Karen Reed was BCC'd on it. She hit reply all, and that reply of her thoughts on responding to that interrogatory went to everyone. And then what had happened was Karen's attorney must have realized it, and he sent an email out. I already covered the Lindsay Clancy lawsuit. I already covered it. Tell me you ain't been watching me without telling me you ain't been. I covered that when I was in Mexico, girl. I covered that in Mexico, that medical malpractice lawsuit. I'm just joshing with you, but I did already cover it. Patrick Clancy filed a lawsuit too, but it's kind of duplicative of what we already read. Suzanne, you sent me something, but it's kind of all blacked out. Oh, well, wait, not really. Microdots shared his thoughts on Greg Connor running for DA. That's what Suzanne sent me. It's too bad you can't unsend emails. Yeah, it's too bad. We'll take a brief look at it because it seems that many of you are interested in it. So let's take a look. So what Karen's attorneys asked was, how about, listen, this was sent in error, so could you please destroy it? And, not use it because it's obviously privileged. And Diller was like, yeah, F you. No, not going to. So let's just take a look quickly at that. And again, once again, in Massachusetts, the way that it works is that the motion is not filed with the court until the motion is made. All parties have responded, and then the entire packet is submitted at the same time. So the first thing that we can look at here, let me know if I freeze again, because this is super annoying when I'm trying to manage all these screens at the same time. So we didn't know about this until it was filed actually with the court, which was, it says it was filed on the 4th. Today's the 7th. So that must have been what, Wednesday? So it was the day after the hearing that we just watched. Okay. There we go. This is Karen Reed's motion for order requiring plaintiffs' counsel. Some of you guys like listening to me read. I like that. I put you to sleep until I start screaming. Good luck with that. Karen Reed's motion for order requiring plaintiffs' counsel to destroy inadvertently produced communication. Karen Reed respectfully requests that the court order the plaintiffs to destroy all copies of an email that she inadvertently sent to plaintiffs' counsel on December 16th. So this goes all the way back to December 16th. By accidentally replying to all in response to an email on which she was blind copied, which unintentionally included plaintiffs' counsel on her otherwise privileged message, which directly related to her legal representation in this case. Okay, this is just one reason why I never, ever, ever, ever would ever BCC my clients on any emails about anything ever. Never, ever, never would I ever, ever do this. We have all been subjected to the reply all email chain in things such as, I don't know, the class moms sent out an email saying, who wants to bring the paper cups? Or who wants to bring the solo cups to the class party, and who wants to bring the paper plates, and who can bring the forks, and who can bring the streamers. And then you're bombarded with 700 reply all messages that you just don't care about. It should be outlawed. It should be, we've all been bombarded with those chains. And we all know what can go. I never would I ever BCC my client on anything, or even CC my client on any communications with other attorneys. They don't need to know about it. If they need to know about it, I'll send them hard copies. If they need to know about it, I will email them a PDF of the documents that I have sent out. But if I spent the time sending each and every client copies of every single correspondence that I sent out on their civil litigation case, I would get no work done. I would never be able to settle cases. I would never be able to go to court. I would never be able to be negotiating with carriers on the phone. I would never be able to have any conferences. Never would I ever. That is problem number one. Okay, because it's too easy that this could happen. But if I was in receipt of something that clearly I was not supposed to be in receipt of, that was sent to me by opposing counsel's client, I would destroy it, and I would not get into a pissing match about what should be done with it. This is especially could be very damaging in, let's say, a matrimonial case, right? Let's say you're representing parties in a contentious divorce, and you're arguing over finances and custody and issues like that. And you're BCCing your client, and then they reply all with some stuff that is not good for anyone, right? Okay, so let's go. Moving on. Despite numerous requests, plaintiff's counsel has refused to delete the email or even to temporarily sequester the message while seeking the court's instructions. Therefore, Reed seeks an order requiring plaintiff's counsel to delete the message and any copies and recover and ensure deletion of any copies sent to his clients or anyone else. In support of her motion, Reed submits the accompanying memorandum of law. Yeah, because now the issue is, since this happened all the way back in December, did Mark Diller get this email that Karen mistakenly sent out? Did he forward it to all his clients? Did they send it to other people? I agree it's an honest mistake, but I'm also going to tell you that it's poor practice to do this in the first place. I wouldn't do it. They did it. It's done. But now the cleanup is going to be the problem. So this is a good learning experience. Or, there's a lot of law students that watch us here. Don't do it. Don't do it if your client wants copies of correspondence, send them hard copies. Just send them hard, be old fashioned. Okay. Put a stamp on an envelope and put it in the mail. It does. It gives me secondhand anxiety too. And I have no idea what she said in the email. And I'm sure it could have been a lot worse. Here's the memo of law that was accompanied to that. From Karen's lawyers. Here's the memo of law. On December 16th, Reed accidentally replied all to an email on which she was blind copied, which unintentionally included plaintiff's counsel. The reply all email directly related to Reed's legal representation and this case. So they're saying it was privileged, despite numerous requests that begin 39 minutes after the reply all email was accidentally sent. Plaintiff's counsel refuses to delete the email, temporarily sequester the message, or even seek the court's instructions. And so here's the thing, because this entire package was submitted to the court the day after the hearing, Rosenberg, Seligson, and Diller were all in on that Zoom hearing. We just watched it together. They all knew about it. They all knew this was going to be filed the next day, and nobody brought it up. Nobody brought it up. They might have considered bringing it up so that they could take the pulse of the judge on what his thoughts might be on this, because this is like just an odd situation. I've never heard of any motion practice involving anything like this before. This could be a case of first impression in Plymouth County. I don't know. Hold on. I'm so thirsty today. Therefore, Reed seeks an order requiring plaintiff's counsel to delete the message and any copies and recover and ensure deletion of any copies sent to his clients or anyone else. Analysis. On December 16th of 2025, Reed's undersigned counsel sent an email to plaintiff's counsel and blind copied Reed so she would be aware of his email. Reed mistakenly replied all to the email to share her thoughts on the legal issue that was the subject of the message, which meant that plaintiff's counsel was inadvertently included on her response. 39 minutes later, another of Reed's attorneys replied all to Reed's email, informed all recipients and particularly plaintiff's counsel that the email had been inadvertently sent and instructed plaintiff's counsel to delete it without reviewing the message. Reed's counsel then followed up shortly thereafter, reiterating these instructions and requesting confirmation that plaintiffs had complied. Instead, plaintiff's counsel suggested he would not. I mean, really? 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 I mean, we know you hate Karen Reed, probably. I don't know if you hate Karen Reed as much as Big Case Mike hates Karen Reed. We're talking about professional courtesy, right? Among lawyers. And if Mark Diller, I don't know anything about him, but if he's a hotshot plaintiff's lawyer in Massachusetts, this is going to follow him around, and it's not a good look, right? It's just not a good look. Nobody's going to want to deal with this guy. Your reputation is like one of the few things that you have, you know? Despite the obvious context clues, he claimed that the email from Reed had appeared to be directed to him, and that somehow Reed's mistake, corrected minutes later, resulted in some undefined waiver of the attorney-client privilege. Reed's counsel followed up with plaintiff's counsel multiple times, explaining counsel's obligations under the applicable rules of professional conduct and case law, but to no avail. I mean, we've talked about the ethics test many times. In addition to the bar exam, you have to pass an ethics test on the rules of professional responsibility. Right, Suze, exactly. This is like Hank trying to pierce attorney-client privilege. It's gross. It's gross. Karma knows your address. You don't want to start playing games like this professionally, because what goes around comes around. What's today's badass affirmation again? F what others think. Do what makes you happy. Has nothing to do with this, but plaintiff's counsel refused to delete the message. Plaintiff's counsel refuse to delete the message, even sequester it or seek the court's instruction. Although most cases regarding inadvertent disclosure involve an attorney accidentally producing in discovery a document that should have been withheld, Massachusetts courts have faced this issue before. Oh, they have. Specifically in 2010, Judge Fabricant decided that a client who replied all to an email to opposing counsel after being blind copied had not waived the attorney-client privilege. And so there's a case from Massachusetts even. In that case, the judge applied the standard that would apply in the more common scenario. A client does not lose the benefit of the attorney-client privilege for an otherwise privileged communication through inadvertent disclosure if the client proves that he and his counsel took reasonable steps to preserve the confidentiality of that particular communication. Goes on to say that the client's transmission of the communication to opposing counsel was obviously unintended. His mistake was of a type that is common and easy to make. Indeed, there may be few email users who have not on occasion used the reply all function in a manner they later regretted. Yes, and that case goes all the way back to 2010. The court highlighted the fact counsel noted the error quickly and immediately alerted his opponent and demanded deletion. And so the facts are very similar to this case, right? The court also explained in that case there were facts that supported a potential waiver, primarily that the same error had occurred before and the disclosing party had not filed a motion to recover the email until much later when the opposing party attempted to use the email. But even with those countervailing facts in that matter, on balance, the court still explained that as a matter of, as a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arriving from inadvertent disclosures, right? It then held that under the circumstances, the email in question was privileged and should be stricken from the record. Here, Reed sent the email in question at 2:28 p.m. and her counsel notified all recipients of the inadvertent message at 3:07 p.m. This is the first time this issue has arisen in this case, and Reed is now serving this motion. Promptly after the message in question was sent. Thus, this is a clearer case than in Charm, warranting the same result, finding that the email is privileged. Reed respectfully asked the court to order plaintiffs to delete the message and any copies thereof. XOXO, Damon Seligson. Well, let's see what they had to say in response to that. Here's their response. Plaintiff's opposition. To defendant Karen Reed's motion for order for order requiring plaintiff's counsel to destroy inadvertently produced communication. It says that they strenuously dispute the allegations set forth therein. Defendant Reed has presented no valid basis to claim impropriety on the part of plaintiff's counsel with respect to the contested email communication. Ms. Reed possesses the burden of proving that the email communication in question is protected by the attorney-client privilege and that such privilege was properly preserved. Well, what should she do? Should she put the email in public court filings so that everyone's going to see it anyway? Oh, Scott, what did I miss? What did I miss? Who's telling me what to do? I missed it. Guess I'll have to go back and read it later. You could tell me on the QT. Plaintiffs contend that any applicable privilege was relinquished when Ms. Reed responded to opposing counsel because Reed and her team failed to adequately mitigate the clear and avoidable risk of inadvertently disclosing confidential communications. What do you mean they shouldn't have BCC'd her? That's your defense? I mean, that's your opposition? Yeah, petty. They're being petty, Jenny. Jenny Lynn says they're being petty. In addition, even if privilege is deemed to apply, plaintiffs are entitled to retain and to utilize the email communication for impeachment purposes should Ms. Reed provide testimony inconsistent with her prior statements. They want a big gotcha moment. Relevant background. During a status conference on November 21, 2025, the parties convened pursuant to Rule 9C at the direction of this court regarding plaintiff's contention that defendant Reed failed to provide a proper response to plaintiff's interrogatory number 1. We went over all of this at the time, seeking the factual basis supporting Reed's third-party culprit defense as required under the rules of discovery. On December 15th, 2025, plaintiff filed a motion to compel further answers to interrogatories from Reed, together with Reed's opposition and the reply brief. That same day, plaintiff's counsel served Reed's team of attorneys via email with the motion to compel. Rule 9A filings included including plaintiff's reply brief. The following day, December 16th, 2025, Reed's counsel responded to plaintiff's email denying the allegations in plaintiff's reply brief and seeking immediate clarification regarding the statement that Reed and her team not only have leaked evidence that now appears inconsistent with the under oath answer signed by Ms. Reed, but also have stated publicly that she has evidence to suggest John O'Keefe was killed inside the house. Unbeknownst to plaintiff, Reed's counsel apparently blind copied Ms. Reed to the subject email chain before sending the response. Approximately 46 minutes later, Ms. Reed replied to all email participants with a fact back to one. Approximately 46 minutes later, Ms. Reed replied to all email participants with factual allegations that are relevant to the aforementioned motion to compel filings and the subject matter of the email chain. Plaintiff's counsel read the email response before recognizing that it may have been sent inadvertently and prior to receiving any notice from the defense counsel regarding same. Okay, so you read it before you realized it was sent by mistake. The content of Ms. Reed's email response was inconsistent with her previous under oath positions in the interrogatory that is the subject of plaintiff's motion to compel. Footnote 1. Plaintiffs will provide the court with a copy of the subject email response for in-camera review at the court's request. In-camera meaning only for the court's eyeballs. The next day, on December 17th, this court issued an order addressing the parties' discovery motions with a request that the parties attempt to narrow the areas of disagreement. With respect to plaintiff's motion to compel, the court noted that Ms. Reed's counsel is requested to suggest to the court how to reconcile the position that there is nothing further for the court to compel, with the information in the 4th, 5th, and 6th paragraphs on the paper. On or about December 24th, at the request of defense counsel, plaintiffs, I got to make this bigger for myself and you. Plaintiffs agreed to hold their motion to compel in abeyance and to serve Reed with a supplemental interrogatory rephrased to specifically articulate all facts forming the basis for affirmative defense number 2, to which Ms. Reed would respond as required by Superior Court Rule 30A. Footnote 2 says, plaintiff's interrogatory number 2. State all facts forming the basis for your claim that plaintiff's damages arising from the death of John O'Keefe III were caused by acts or omissions of third parties for whom Ms. Reed is not responsible, as set forth in affirmative defense number 2 in your answers to the plaintiff's complaint. Okay, so whatever email she sent apparently had something to do with the third parties that she believes caused John O'Keefe's death, their acts or omissions for whom she is not responsible. It's the case that keeps on giving. Plaintiffs agreed to withdraw their motion to compel if Ms. Reed provides an acceptable response to their supplemental interrogatory. Right, we went over all of that at the time, as I recall. Argument. Defendant Reed's implication that plaintiff's counsel has failed to fulfill their obligations under the applicable rules of professional conduct and case law with respect to Reed's email response has no merit. Plaintiff's counsel has not disseminated, leaked, or otherwise acted unethically in any way with respect to the subject email. Despite Ms. Reed's contention, plaintiff's counsel is under no obligation to destroy the communication at the direction of defense counsel or to affirmatively seek court intervention, whereas Ms. Reed has the burden of proving that the contents of her email response were privileged and that she neither intentionally nor unintentionally waived any such privilege at the time of her reply. Furthermore, even if this court finds Ms. Reed did not waive any privilege, plaintiffs are permitted to retain and use the subject communication to impeach Ms. Reed in the event she provides under oath statements inconsistent with her statements in the email. Well, whatever it is that they think that they have, it seems pretty clear that it is likely privileged. You can waive the privilege if, for example, you insist on someone else coming in with you for a meeting to meet with your lawyer. If there's a third party in the meeting with your lawyer, you're waiving privilege. Without seeing the email, it is hard for me to opine on whether that email is indeed privileged or whether that email, whether it was clear that she did not intend to send it to plaintiff's counsel. But let's be honest, she was probably responding to her attorney and hit reply all by mistake. And Diller knows it. Why does he need to be a dick? I don't know. Not a good look. Defendant Reed waived any privilege with respect to the subject matter of her email response. Let me just see how much longer this goes on for. So he's going to say that she waived privilege because in order to show that it's privileged, she has to show, one, the communications were received from a client during the course of the client's search for legal advice from the attorney in his or her capacity as such. Two, the communications were made in confidence. And three, the privilege as to these communications has not been waived. I guess the bolded section where they say that the privilege was waived is what they're going to rely on. They're saying it's a question of fact for the judge. Here, unlike the typical scenario involving an attorney's accidental production of confidential materials, Ms. Reed herself chose to share her opinions on the legal issue. That was the subject of the email chain when she responded to the group. Yeah. Thank you very much. You, lady in the back, says, Diller not realizing that his lack of integrity is like pressing the gas pedal as you drive off a cliff. Columbo Wannabe says, in my opinion, Diller is creating more billable hours. In certain cases, I would agree with you, except to say plaintiffs' lawyers are not paid by the hour. Plaintiffs' lawyers take cases on contingency, which means they don't recover unless you win the case. So if the O'Keefes win a large verdict or settlement, then typically the usual retainer in New York anyway is 1/3 of the recovery goes to the attorney. But in other states, it can be as high as 40%. If the case goes to trial, it could be as high as 50%. So he's not billing hours here. He's going to get paid on contingency, which makes this even less compelling. At least if he was billing for the hour or the 10th of an hour, you could maybe understand it. Regardless of whether Ms. Reed's email response was inadvertent, this court should find that Ms. Reed waived privilege due to her failure to take reasonable precautions to prevent the disclosure of privileged communications. Yeah, we should spank her. We should spank her because she didn't take reasonable precautions. Everyone's done this at some point in their life. The horror of the reply all. Everyone knows what I'm talking about. The SJC held that the modern trend has moved toward a principle that the privileged status of a communication or document is not lost when an attorney and client take reasonable precautions to ensure confidentiality. But, for example, a privileged communication is nonetheless overheard. In support of her motion, the defendant relies exclusively on the trial court decision in Charm v. Cone, which is what we just read, which seemed to be directly on point here, that the client did hit a reply all. But they say defendant Reed and her legal team conveniently disregard the clear message from Judge Fabricant, warning future litigants of the preventable risk taken by Reed and her counsel here. Okay, well, the judge is warning future litigants who are not going to read that decision. So that kind of rings hollow too, don't you think? I don't know, just spitballing with you here, just spitballing. Right. Contempt. Sherilyn says, why the grandstanding? He knows better. Silly. Hello, Jerry Tamps. Hello, Jerry Tamps. In finding the question is close, Judge Fabricant cautioned, Cohn's counsel's practice of sending him a BCC of emails to opposing counsel with a CC to co-counsel gave rise to a foreseeable risk that Cohn would respond exactly as he did. In sending his response, Cohn would have had to have known what he was responding to, but nevertheless failed to take careful note of the list of addresses to which he directed his reply. Sometimes you do things from your phone. Your phone, like, your finger just slips because he has nothing, says Mama MSN. You might have a fat finger. It might just hit the reply all. I mean, we've all done it. It's understandable. On the other hand, and then he bolds this part, a client who seeks to preserve the privilege has a responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Lawyers should advise clients to be careful and should avoid practices that exacerbate risks. Here, it appears that both Cohn and counsel were less vigilant than they might have been. They and others should take note, and this is bolded and underlined. Control B, Control U, all together now. Reply all is risky. So is BCC. Further carelessness may compel a finding of waiver. Well, I don't know. Who's going to make the shirts? Reply all is risky. So is BCC. Shoot me. I mean, like, what? Thank you, Judge Fabricant. It was a butt dial reply. That's exactly what it was. It was a butt dial BCC reply. It was a butt dial reply all. No, they're not using this to say that they can ask for more communications, BB. They're trying to say that the one that they got, that she obviously meant to send to her attorney. Well, they're saying it's not obvious that she meant to send it to her attorney. They're saying they should be able to use that one against her. And they shouldn't have to destroy it. Here, the precautions taken by Reed and her team to ensure confidentiality of communications were careless, not reasonable. In all likelihood, by her own direction and or by recommendation of counsel, Ms. Reed has been blind copied on all email communications with opposing counsel since the outset of this lawsuit. So therefore, she deserves to be spanked. Come on, man. Like, you can't be serious with this. It's not, the serious lawyers don't write these kind of motions. They just don't. Your reputation follows you around for decades, man. What are you doing to yourself, Diller? Why you gotta act all crazy? It's just crazy. Why? In all likelihood, Ms. Reed has been blind copied on all email communications with opposing counsel since the outset of this lawsuit. Well, then we're surprised that it's the first time she did it by accident. Like, who cares? It's insane. As cautioned by Judge Fabricant, this practice exacerbated the known and obvious risk of broadcasting privileged communications to opposing counsel. Okay, so now you're admitting, in the next breath, you're admitting that it was privileged? Right, because your case sucks. Listen, if you had hard and fast, real evidence that John O'Keefe was hit by a car and a car hit John O'Keefe and Karen Reed did it and caused the death of your client's loved one, Boston Police Officer John O'Keefe, you wouldn't be behaving this way like a petulant child. They love using Karen's words against her. Right. If you had such a slam dunk case and experts to prove it that didn't do blue paint experiments, you would just do what any gentleman would do or any lady lawyer would do, and you would delete it and you shred it, and that would be the end of that. You wouldn't make I don't know. This is just so beyond the pale of anything that real lawyers do, in my experience, that it's silly. Foreseeable risk, which occurred here, could have been easily avoided. For example, defense counsel could have simply forwarded the email. Yeah, we get it. Mm-hmm. Under the circumstances here, including but not limited to Judge Fabricant's warning to future litigants, right, from 2010, this court should find that Ms. Reed waived any privilege with respect to that communication. We should be allowed to use it. And even if she did not waive privilege, we shouldn't be able to use it for impeachment purposes. I mean, the risk of unethical opposition. Yes, slow cupcake. Yes. They should all be punished because of a BCC. Like, really? This is really what you want the court to believe? And who knows what the court's even going to do here? Who knows? They've got some case law here that says that while a party's inadvertent disclosure of a privileged communication did not amount to a waiver, such finding did not preclude use of the communication by opposing counsel in the future to assess credibility. And this is a civil case. Karen's going to have to testify. She's going to have to give a deposition. I have no idea what the email sent, what the email said. I don't know if it's inconsistent with her prior statements that she's given under. Well, she hasn't testified under oath ever, so it couldn't be inconsistent with anything she's ever testified about because she hasn't. Hi, Stephanie. I'm good. How are you? I'm good. How are you? Thanks for your 5, Stephanie. I'm going to get to the super chats in a minute. I just want to finish this document because I got some other things I need to do tonight. All right, moving on. So they want to be able to use it against her regardless. Here, Ms. Reed's choice to respond to the entire email chain and make factual assertions directly relevant to disputed issues in this case, whether inadvertent or not, is a bell that cannot be unrung. No, it can. You could be a gentleman and destroy it. You could. I mean, am I alone in this? Has anybody else? I saw Peter Tragos went over this. I didn't watch it because I wanted to do my own reaction video to this. Like, what's the general consensus out there? Has anybody said that Diller is correct and that this should be able to be used against her? I mean, it's kind of sleazy. It's kind of gross. Requested release. Consistent with the above rulings, the plaintiff should be permitted to retain Reed's subject email communications for use at trial and to further depose Ms. Reed concerning the purpose and meaning of the subject email communications with any such conditions as the court deems necessary. LML Bun says, this is so sad. I've done it before. Nothing but bad things I didn't want the other person to see. Right? Right? Taillight Fairy's like, when you work for free and can't think straight. I mean, what? What are we doing? Oh, good, lawyer. And brother counsel agree with you. Great minds. I'm very happy to be in good company. It's childish. It's ridiculous. The entire click case is sleepy. Did you mean sloppy and gross? Sleepy and gross. It's sleazy, but not a surprise, says Mark, given that, but it's gross. Thank you, Krista, but I don't pay attention, so I don't even know what you're talking about. All right, requested relief. Wherefore, the foregoing reasons, the plaintiff respectfully requests that the defendant Reed's motion must be denied. So they want the court to find, one, that defendant Reed waived privilege with respect to the email response on December 16th and its subject matter, and 2, permit the plaintiffs to retain a copy of the subject email for use at trial and to depose Ms. Reed concerning the purpose and meaning of the subject email communications with any such conditions that the court deems necessary. And they would like a hearing on this matter. And I think that a hearing's already been granted, but just hold please, because there's a reply to this from Karen's lawyers. I can't even imagine what Karen was thinking after she hit reply, or whether she is the one who figured it out, or whether her attorneys are the ones who figured it out. Let's see. There's a reply. Okay. I just want to see. Seligson also put an affidavit in. Hold on. Okay, and this is on February 4th. All right, let's look at this. Seligson put in a reply, and this is Seligson's affirmation to the reply, which is going to give us a little bit more inside information about what went on here. The fact that there's this much motion practice on something like this is mind-blowing. But let us just. Before we go, yeah, right. It's not like they received an inverted video. Exactly, Lola. Where are the grave concerns? Where were the grave concerns then? Derek says, about you, Nurse Kim, Emily, and Samantha in episode 5 of my hard/dark comedy. Thank you. I appreciate that. I'm not giving that woman any more air. I appreciate you. Thank you, Derek, for your 5, but please don't. Thank you. JDT, I don't want to give it any more air. So when other people are out there giving it more air, like then it keeps, it's like a fire. You know how a fire needs oxygen to keep burning? We learned about that this week in the Faust case. Fire needs oxygen. It needs a window to be open or something to make it keep going and really roar. Like adding flames to the fire is not helping me at all. It's not. Like, I don't want anything to do with any of that bullshit. And if it keeps up, then this will be the last stream that I do on any of this stuff. So guide your actions accordingly. Hi, JDT character girl. Thank you for being here for 22 months. Chill crochet and Sunday morning from Oz. I love you too. Love you too, girl. Kathleen, 6'7". Look for the Friends episode. Is that where it comes from? I don't know. Thank you for hanging out for a year. Steph says, I'm sorry. I have never sent a super sticker. I did not know how to message it. I'm sorry. No, don't apologize. Listen, you keep throwing money in there. That's sweet of you. I appreciate it so much. And thank you I feel honored that you would send me your first super chat. Thank you so much. Nanny a Business says it ought to be at least as difficult to send a reply all as it is to delete a free iPhone video game, Lordy. Yeah. Or even like, you know how they there are certain things where you have to confirm 10 times before they will delete something. That should be something you should have to confirm like 50 times. Or like, yeah, do not make me pull this car over. Thank you, Sally. Do not make me pull this car over. I agree with you. Cruise motions are going to be tomorrow. Not talking about it tonight. The whole first half hour of this stream was recapping to get more people interested in the Faust trial tomorrow. Tomorrow. I love you. Tomorrow. And not for long, because tomorrow's the Super Bowl. And go Pats. Hold on. Hold, please. Okay. Pierce said, maybe Karen just shared a Dilbert comic. I wish. I know. Me too. I wish too. I wish. Aunt Bibi says, years ago, my boss was beaching about her boss to me in an email. Problem was she accidentally sent it to her boss, not me. Brother Counsel said the same thing. He never BCs any client. Nope. Thanks for your 10, Aunt Bibi. Steph, I'm sorry, but I wish they would all just leave Karen alone. They put her through so much. Agreed. Hopefully she'll be the last one holding the bag of money. You know, hopefully she will. Hopefully she'll win her civil suits. And hopefully she'll get lots of money and they can't write a check big enough to her for all of the things and the horrors that she has been through. We still never went over the Haas defendant's motion to dismiss. If you guys want to do that, let me know. Thank you for your 5. Props to next witness. You are obviously the first choice. Oh, you're a sweetheart. Thank you for being here for 18 months. And Steph said hi, and I said hi back. And then Bruins Girl is here, and she became a new member, and I'll allow it. Hold on. Hold, please. 1 second. I got to show you another prop. We have over here, little angry Messier. We have a little angry Mark Messier. I'm a Rangers fan until if and when the Bruins, get further than the Rangers, and then I switch over, which, as you know, the Rangers suck this year, so it's okay. I will allow it. Let me just boop, boop, boop. Check one more thing. Oh, look at Jen bought me 5 matcha lattes, and she says, thanks for being the best. So happy to be a cupcake from Colorado with love. Oh, my daughter called me yesterday. She's like, Ma, I'm sitting on I'm laying on the hammock in my shorts. It's 65 degrees in Boulder. I'm like, what? It's like summertime. It's like you guys are watching the Super Bowl and you're in shorts. I said, wait till you go skiing in March and the girls are skiing in bikinis. You ain't seen nothing yet. Thank you very much, Jen, for buying me 5 matcha lattes, and I am very jealous of your location. Very, very jealous. Mama She, thank you for your very generous $100 Cash App. She says, I'm so grateful. I'm so grateful for you for doing what you do. I'm so grateful for you, Mama She, and all of you who care enough to watch me yell and listen to me yell constantly and get outraged. And for being outraged with me. And Mrs. Goodman is here. Deanna, thank you for your Venmo. She says, hearts and cupcakes. Hearts and cupcakes. Okay. This is the affidavit of Damon Seligson, and this has to do with the as aforementioned motion to delete the reply all email from Karen Reed. And he says, I'm over the age of 18. I am licensed in Massachusetts. I've been a member of the bar since 1996, and I've been in good standing ever since. I am a shareholder of the law firm She and Finney Bass and Green. I work in the Boston office. I am counsel for Karen Reed. I'm providing this affidavit in response to Karen's motion requiring plaintiff's counsel to destroy the email we've been talking about the whole time. On Tuesday, December 16th, 2025 at 2:17 p.m., I sent an email to Mark Diller, Esquire, counsel of record for the plaintiffs. In the email, I asked Mr. Diller to provide me with the basis for certain assertions that were included in his opposition. Copy of that email is attached as Exhibit A. All right, good. Let's look at it. Here's the email from Damon to Mark Diller with a CC to Charles Waters. These are the other attorneys. Aaron Rosenberg, Elizabeth Little, Alan Jackson, Caleb Mason, BB Fell, Daniel Buck. So it's opposing counsel and co-counsel. We're all CC'd. Subject, reply brief. Mark, in your reply brief filed with the court, you state, in so doing, Reed and her team not only have leaked evidence that now appears inconsistent with the under oath answer signed by Ms. Reed, but also have stated publicly that she has evidence to suggest John O'Keefe was killed inside the house. We deny having leaked evidence. Please identify your Rule 11 bases for making this claim, as we think this needs to be cleared up immediately. Okay. So if Karen Reed replied all to this, she likely went off. And it went to Mark Diller, Charles Waters, Rosenberg, Little, Jackson, Mason, BB, everybody. It went to everybody. But let's go back. My email copies by CC certain of the lawyers who have appearances in this action and includes my client by BCC, blind copy. As a general practice, I do not blind copy Ms. Reed on email exchanges with the counsel. I have reviewed my emails to Ms. Reed, and I cannot find a single instance other than this one time that I BCC'd her on communications with other counsel. Instead, with any communications from and among counsel that are shared with Ms. Reed, it is my practice to forward those exchanges to her by separate email. The fact that I BCC'd Ms. Reed on my December 16th email to Mr. Diller was a one-time event. Okay, he's saying, look, I'm based on the case law that Seligson has that Diller has provided you with, Your Honor, saying that, Judge Fabricant warned all lawyers in 2010 that they should never, ever do this. He's like, Judge, I never, ever do this. I never do this. This is the first time I've ever done it. Whether it's going to work in his favor, I don't know. Using her cell phone at 2:28 p.m., Ms. Reed replied to the email, but inadvertently replied to all recipients. That's what I thought, probably on her phone. Realizing that Ms. Reed's reply email had been sent to all and that replying to all was inadvertent, my law partner, Aaron Rosenberg, immediately communicated with Mr. Diller by email at 3:07 p.m., explaining that our client's reply to all was inadvertent. In his email, Mr. Rosenberg requested that it be deleted without reviewing pursuant to the Mass Rules of Professional Conduct. Copy of the emails attached is Exhibit B. Let's read that. From Aaron Rosenberg, Tuesday, December 16th, 3:07, to Karen Reed and Damon Seligson with a CC to Mark Diller and everybody else. Mark, Dan, Jason, this email was sent inadvertently. Please delete it without reviewing pursuant to the Massachusetts Rules of Professional Conduct. And then that email is redacted. At 3:51 p.m., I sent a follow-up email to Mr. Diller reiterating that the reply from Ms. Reed was inadvertent, and I expressly requested, 1, that he and his legal team refrain from reviewing or disseminating the email or any attachments. 2, that he and his legal team delete the email and all attachments from his system and any backups. And 3, that he confirm in writing that no portion of the email or attachments has been read, copied, saved, downloaded, or otherwise retained. And 4, that he confirm deletion of all such materials and any derivative copies. Copy of the email is attached here to is Exhibit C, which reads, Dear Mark, okay, this is from Damon Seligson to Diller. Following up on Aaron's request below, the email he refers to was inadvertently sent to you from my client with the subject RE reply brief at 3:02:47 p.m. Eastern. It was not intended for your review. The email and any attachments thereto are privileged and confidential attorney work product materials. Pursuant to your ethical obligations under the applicable rules of professional conduct, you are hereby formally notified of the inadvertent transmission. You are directed to immediately refrain from reviewing or disseminating the email or any attachments. Delete the email and all attachments from your system and any backups. Confirm in writing that no portion of the email or attachments has been read, copied, saved, downloaded, or otherwise retained, and confirm deletion of all such materials and any derivative copies. We appreciate your attention to this matter and request written confirmation that you did what we said. XOXO, Damon. Mr. Diller refused. Accordingly, we served the plaintiffs with Ms. Reed's motion. XOXO, Damon Seligson. Well, the judge has set this for a hearing, and that hearing is going to be, I believe, I put it in my calendar. I will tell you when that's supposed to be. There's one follow-up hearing to the Zoom hearing that we just watched. That's going to be happening allegedly on the 12th at 4 p.m. And then they scheduled another hearing I think it's on the 17th at 3 p.m. or vice versa. Can't remember now when I closed the docket. So there is that. Hold please for 1 second. All right. Who wants to come back tomorrow to learn a little bit more about the Faust case and the pretrial rulings? Raise your hand. Well, I don't care if you want to do it or not. I do, and I'm scheduling it for tomorrow. All right. Hold please while I set it up so I can redirect you there. What should we call it? What should we call it? Review of pretrial shenanigans. Because we really need to know more. What time should we schedule it for tomorrow, my friends? I don't know. I'm thinking it's the Super Bowl. We got to get our groove on. I don't want to do it too early because I really need to catch up on my sleep. What time is kickoff? Yeah, I was thinking like noon or 1. What time is kickoff tomorrow? Like 6:30? It's later usually than it feels, right? 7 a.m. DK, have you met me? Tomorrow's Sunday. For the love of the traveling Mary. 1 p.m. I say 1 p.m. Executive decision. And I'm going to redirect you all there so you don't even have to worry. Like it's gonna all be automatic. It's fantastic. Maybe we can do like a brief review. That's tomorrow's February 8th, right? Okay. And look at some of the 412 pretrial rulings. Okay, that's what we're going to do. Now, second thing. Let me just set up the redirect, and then I'm going to let you go, maybe, if I feel like it. Hold, please. I'm in a mood. Can you tell? Let's see. It is the easiest thing for me to do, though, is to set up the redirect. So you can just go there. You can be sent there after this, and then you hit the reminder button, and then you're good to go for tomorrow. You know what I'm saying? I just got to make a thumbnail. This is like, you guys don't realize like how much work this is. It's like a lot of work, but I love it so much. It's like a labor of love. Okay. Here's what I'm going to do. I'm going to put the next witness video description in the chat. I mean, in the show notes below this video, so you can go watch it and give next witness a sub and a like. I'm going to put the microdots new video in there also because you need to see it. I forget. Wait, I'm trying to remember what it's about, but I did watch it last night. Drop microdots. What else do I need to do? Give me some more chores. Yes, let's see. His most recent drop is called The McAlberts Are Terrified of This. You need to watch it. And then there's another one. Well, the last one before that was 2 weeks ago, which is called Karma, How Michael Proctor Ruined His Life, which is also amazing. So why don't I just do that like while we're sitting here. Thank you, Kelly, Chloe Bit. So we must have quit. Says we appreciate and love you with all of our hearts. Thanks for being here for 15 months. Steph says, thanks for saying I have a cute puppy. His name is Balin Tyler. He says, hi, Melanie. Hi. Your puppy learned how to throw $5 super chats in. I love that for you. Jody's here. She became a member. She's amazing. Redondo Beach is here. And I mean, who doesn't want to be in Redondo Beach right now? Is your weather better than Boulder? It's one of the places that I've saved on my weather app. So I'm going to tell you all right now in Boulder, it's 48, but there was a high of 61 today. Tomorrow's going to be sunny also with a high of 61, which feels higher also when you're like a mile high, right? And also Cancun right now is 67, but tomorrow's going to be a high of 79. In Manhattan Beach, which is what I have in my weather app, tomorrow is going to be a high of 78 and sunny. Really? You guys are getting like the best Super Bowl weather. And wait, I'll let you know what it's going to be like here tomorrow in New York. It's going to be, well, right now it's 5 degrees, but it feels like negative 15. Oh, yes, I read that right. And tomorrow is going to be a low of 1 degree, a high of 16 degrees, but it's going to be sunny. So we got that going for us here. And Music to My Soul says, but Melanie, the Puppy Bowl starts at 2 p.m. Thank you, Music to My Soul. Are you enjoying your jewelry? You enjoying all your jewelry? Okay. Come visit again because I have to know where you stayed in El Segundo because the room decoration was so cute. I don't think I stayed in El Segundo. I stay usually in Manhattan Beach or Hermosa. I don't know. Oh, you know where I can't tell you what hotel I stay at. I don't know if I was in the Airbnb when last time I streamed from there or if I was in a hotel. I don't remember, but I won't say. I'm not going to say. Thank you all for coming and hanging out with me today. This was a lot of fun. Stay cool, stay kind, stay classy. I'm going to teleport you to the morning stream. And not really morning. It's going to be 1 p.m. So we'll see you tomorrow. If you want to learn about the Faust case, you need to. You really need to. All right, you guys. When I end stream, it's going to send you right there. All you do is hit the reminder button and come back tomorrow to hang out with me some more. Because who wouldn't want to? We got to have so much fun here. I love you guys so much. Stay cool, stay kind, stay classy, do all the things. Here's the world's tiniest leaf blower in honor of all my friends from Norfolk County. I'm going to open it up so we can play with it one day. I'll see you tomorrow at 1 p.m. Buckle your seatbelts, kids. It's going to be a bumpy ride. Peace. Thanks, moderators. I love you. Couldn't do this without you. You know that.